Musician Chuck Red was a fixture of the Kennedy Center's Christmas Eve Jazz Jam for over 2 decades, performing in a complimentary holiday event that became a seasonal staple for local audiences. On December 18th, 2025, the Kennedy Center's board of directors renamed the institution the Donald J. Trump and John F. Kennedy Center for the Performing Arts. The very next day, Red emailed the center to say that he disagreed with the change and he canceled his performance. 5 days later, on the day the concert would have happened, Red told the Associated Press exactly why he'd canceled. The center sued Red for breach of contract. The Superior Court of the District of Columbia threw the entire case out, applying DC's Anti-SLAPP Act to a morals clause dispute in a way that tests exactly how far that clause can reach when it collides with a statute built to protect public speech. Also, there was the minor issue that the venue's own contract may not have been binding in the first place. I'm Scott Hervey, a partner with the law firm of Weintraub, Tobin. And today I'm joined by my partner, Richard Buckley. Today we're going to break down the facts, the procedural path this case took through the DC Superior Court, how the Anti-SLAPP Act burden-shifting framework works, what the court actually found, and what this means for every venue, studio, and producer relying on a morals clause to police what performers say in public. We're going to talk about all of that on today's installment of The Briefing. Richard, welcome back to The Briefing.
Thank you, Scott. Great to be here.
Yeah, great to have you, especially for this one. Okay, this one has a little bit of everything, kind of like an everything bagel. So 20 years of history, a morals clause, a statute built to protect public speech, and a venue that changed its name and then walked away with nothing but an attorney's fees bill.
It didn't really go the way they wanted it.
No, it did not. All right, let's get into it. All right, let's start with the facts. Let's talk about who we are talking about.
The defendant, Charles Red, aka Chuck Red, is a musician who for more than 20 years performed at the Kennedy Center's Christmas Eve Jazz Jam, part of the center's holiday programming going back decades.
According to the center's amended complaint on November 23, 2025, Red was presented and at least according to the amended complaint, Red agreed to a written artist agreement for that year's performance, which included a $6,500 fee running from noon till 1 o'clock, and that fee covered the performance itself, encores, a sound check, and a production walkthrough.
Standard engagement terms.
Right, standard except for one thing. That year's agreement also included a morals clause, a fairly broad language requiring Red to act with, quote, due regard to public morals and conventions, and giving the center the right to terminate if his conduct might shock, insult, or offend the community or public morals or decency. Really like pretty vanilla morals language.
And that morals clause becomes key to this dispute. Now, here's the event that triggers everything. On December 18, 2025, the center's board of directors renames the institution the Donald J. Trump and John F. Kennedy Center for the Performing Arts.
Right, which, to put it mildly, was a controversial decision. So the very next day, December 19th, Red emails the center to cancel his performance, telling them he disagrees with the name change. 5 days later, on December 24, the day the concert would have happened, Red emails the Associated Press and says, quote, when I saw the name change on the Kennedy Center's website and then hours later on the building, I chose to cancel my concert.
And at that moment, this becomes a lawsuit. The center's amended complaint alleges that Red violated the morals clause by, in its words, abusing, quote, the public forum provided to him by the center in order to make a political statement, end quote. They sued for breach of contract, claiming lost goodwill, wasted marketing spend, and sunk costs from a free concert that never happened.
Right. All right. So the center files its original complaint on March 5, 2026, and just one day later files an amended complaint on March 6, narrowing everything down to a single count, breach of contract. Then on March 27, 2026, Red responds, but not with an answer. He files two motions at once. First, a special motion to dismiss under DC's Anti-SLAPP Act, and second, in the alternative, a Rule 12b6 motion to dismiss for failure to state a claim.
The court held a motion hearing on May 18, 2026, and on June 5th, Judge Tanya Jones-Bozier granted both motions, the special motion and the Rule 12 motion, dismissing the amended complaint and setting a briefing schedule on attorney's fees. Now, this is a Superior Court order, not a DC Court of Appeals decision. That distinction matters. The ruling is persuasive, it's well-reasoned, and the docket shows it as a closed case, but it's a trial-level ruling. It doesn't bind other Superior Court judges the way an appellate decision would, even though it leans heavily on Court of Appeal precedent to get there.
Right. All right. Okay. Before we get to what the court actually found, let's talk about the framework it was applying, because the DC anti-SLAPP statute does a lot of work in a lot of cases well beyond entertainment law.
It sure does. SLAPP, two Ps, stands for Strategic Lawsuit Against Public Participation. The DC Council passed this statute because, in its own words, some lawsuits are filed by one side of a political or public policy debate, specifically to punish or to prevent the other side's speech. The council found these suits are often without merit, but the target, the defendant, still has to spend money and time and resources defending against them, which chills people from speaking up in the first place.
Right. Mechanically, it's a two-step burden-shifting test. Step one, the defendant, the movant, has to make a prima facie showing that the plaintiff's case arises from an act in furtherance of the right of advocacy on an issue of public interest. What's an issue of public interest, you ask? Well, it's defined very broadly. It covers statements made in connection with a matter before a legislative, executive, or judicial body. It covers statements made in a place that is open to the public or a public forum in connection with an issue of public interest. And there's a catch-all: any other expression or expressive conduct that communicates views to the public on an issue of public interest.
And more specifically, the statute defines it to include things like health or safety, environmental, economic, or community well-being, the district government, a public figure, a good or service in the marketplace. It specifically, though, excludes purely private interests. If you're just protecting your own commercial interests rather than commenting on something of broader significance, that's not covered.
Okay. So once the defendant clears that first hurdle, the burden then shifts to the plaintiff. So step two, the plaintiff has to show a likelihood of success on the merits, not proof, but an evidentiary basis that would let a reasonable jury rule in the plaintiff's favor. If the plaintiff can't clear that bar, the special motion is granted and the claim is dismissed at the pleading stage before expensive discovery ever even starts.
So, Scott, let's talk briefly about the fee shifting part of the statute. A successful movement is presumptively entitled to attorney's fees. The DC Court of Appeals has been clear. There's no requirement that the suit be a classic SLAPP filed with a bad motive or then it be utterly meritless. Even a plaintiff who genuinely, in good faith, believes that their case has merit can still end up paying the defendant's fees if they can't clear that likelihood of success bar.
Right. And just to be clear, intent doesn't save you. That's the whole point of the fee shifting provision. It makes the target of the suit whole rather than punishing bad actors specifically. It's an exception to the American rule, and it's a real deterrent against filing these suits in the first place.
And just for those out there interested, the American rule means that both sides pay their own attorney's fees.
Right. As opposed to the English rule, where in all lawsuits, the prevailing party pays gets the attorney's fees reward. Under the American rule, You only get your attorney's fees back if it's like in a term in the contract or if it's specifically provided by a statute, like
Correct.
here. Okay, so now let's apply the framework to what actually happened here because the court's reasoning moves through several independent grounds.
The court found that Red cleared the bar easily on two separate grounds. First, his statement to the Associated Press explaining why he canceled was made in a public forum in connection with an issue of public interest, a public official's name being added to a public institution. Second, his decision not to perform, made for that same reason, counted as expressive conduct, communicating his views to the public.
Right. The center didn't dispute that Red's statement related to a public official and a community debate over the name change. What they argued instead was that their claim didn't actually arise from that speech, that this was really just about Red failing to show up for a job that he agreed to do. And that was the issue in American Studies Association versus Broner, which holds that the protected activity has to be the actual basis of the legal claim, not merely factually related to it. So that's a good argument in the abstract.
And I get why the center made it, but it didn't work here. The center's own amended complaint alleged, in its own words, that Red abused the public forum provided to him by the center in order to make a political statement. It cited his AP statement repeatedly as the basis for the alleged breach. The court found the claim was, quote, grounded in and inextricably intertwined with Red, end quote. So they pled themselves into anti-SLAPP coverage.
Yeah, essentially a self-inflicted injury here.
Right.
Right. If the center had drafted a complaint that stuck strictly to he didn't show up without characterizing the reason as a punishable political statement, this might have come out differently on the threshold question. But once your own complaint says the breach was about abusing a public forum to make a political statement, well, you've tied your claim directly to the protected speech.
And it's a real lesson and sometimes a nightmare for litigators. You have to be careful what your complaint says. So now the burden shifts to the center to show a likelihood of success. And this is where the case falls apart on a second independent track, contract formation.
Right. The center's whole theory depends on there being a valid signed artist agreement that included the morals clause, but it's undisputed that despite what was in the amended complaint, that Red never signed the 2025 agreement. The center followed up with him repeatedly in December on the 12th, the 13th, the 14th, the 15th, the 16th, and 17th, and the 18th. Sorry, not the 16th, because the contract remained unsigned and Red canceled on the 19th.
And the morals clause specifically, that was a brand new material term. It wasn't in his prior year's agreements. Because the proposed agreement added a new material term, it operates as a counteroffer, and a counteroffer only binds the other party if they actually accept it. And Red never accepted it.
Right. Never signed it, never discussed it, never did anything the center could point to as manifesting acceptance. The center tried a course of dealing argument, 20 years of doing business together should count for something, right? But the record actually cuts against them. Both Red in his supplemental declaration and a former center employee confirmed that in over 2 decades, no performer had ever gone on stage at the center without a signed written contract. That's course of dealing, if anything, and that proved the opposite point. To that end, the court said no signed agreement, no accepted counteroffer, no binding morals clause, no breach.
And even setting that aside, this is a free concert.
Right. Third independent ground, damages. The center alleged lost goodwill, wasted marketing, and sunk costs, but the records show that the tickets were free. The center's own marketing didn't feature Red specifically, and because multiple performers canceled, not just Red, the entire Jazz Jam was called off. So there were no replacement costs either. The lost goodwill allegation was conclusory, and the court noted something almost ironic. The center's own president had written to Red beforehand, ascribing the Jazz Jam's ticket sales and donor support as already lagging before any of this happened.
Right. So the goodwill problem may have predated the alleged breach entirely.
Right. Well, that's certainly how the court read it. Between the anti-SLAPP analysis, the failed contract formation, and the absence of damages, the court granted both the special motion and the 12B6 motion. Three independent grounds, any one of them which would have been good enough on its own, I think.
And after Red prevailed, he moved for attorney's fees and costs under the anti-SLAPP statute. And just last week, the court awarded Red just over $250,000 in fees and costs.
Right. All right. So let's talk about what this actually means going forward. And I want to focus specifically on the tension this case highlights between moral clauses and a venue's ability to police what a performer says publicly. And not really a venue. It could be any contracting party's ability to police what their employee or what their contractor says publicly.
Right. And certainly morals clauses aren't new. Venues and producers have used them for decades.
Right. Venues, producers, studios. And historically, these clauses are aimed at scandals, arrests, public misconduct, things that embarrass the or tarnish the reputation of the hiring party through the performer or individual's personal behavior. What's different here is that the center tried to use the clause to reach a performer's public political statement criticizing the venue's own institutional decision.
And that's what creates the anti-SLAPP exposure. A morals clause written broadly enough to cover anything that might offend the community or reflect unfavorably on the hiring party can, in theory, be stretched to cover a performer's political or social commentary. But the moment the hiring party tries to enforce that clause against speech on a matter of public interest, it isn't just enforcing a contract anymore, it's suing over speech. And that's exactly the category of lawsuit that anti-SLAPP exists to weed out.
And this matters well beyond concert halls. Think about brand ambassador agreements, influencer contracts, sponsorship deals, and even standard talent deals where a company wants a morals or conduct provision broad enough to control reputational risk. But the person on the other side of that contract has opinions and increasingly a public platform to share them.
So if a brand or a studio tries to enforce a morals clause against an influencer or actor's public comment on a controversy involving the brand or the studio itself, not personal scandal, but commentary on the company's own conduct, that enforcement action is going to look a lot like this case in front of a court in a jurisdiction with a broad anti-SLAPP statute. So, Scott, what is the actual guidance for venues and producers drafting these clauses?
Okay, that's a good question, Richard. It has a couple of layers to it, right? So first, I think you do want to be broad enough. If we're talking about a hiring party's remedy just to terminate an engagement, you want it to be broad enough so that it covers all types of reputational risk. On the flip side of that, if there's a risk that you need to sue to enforce that contract or enforce your right to terminate or somehow collect damages due to the termination, that's where you may run into these issues. So I see these two interests being diametrically opposed to each other, right? Because if you're focused on a lawsuit and having your lawsuit survive an anti-SLAPP motion, you would want your morals clause to be more precise, maybe aimed at personal scandal and criminal conduct. But if you really are more concerned about protecting your organization from reputational risk, which generally is the case, then you want that clause to be much broader.
Yeah, I agree. You said that there were multiple layers. What's the next layer?
Well, I mean, those were the two layers of the sandwich, right? But let's talk about, what happens before you sue to enforce a morals clause over something. Let's say it's something a performer said, right? Let's say you're vindictive enough, as maybe the case was here, to sue a performer who canceled for damages, or to whatever the case might be. So if before you sue for contract damages over violation of a morals clause, you got to do the anti-SLAPP analysis first, especially like in DC and in most jurisdictions with broad public interest definition. That kind of speech, the kind of speech that we saw here in this case, it's very likely protected, and being on the losing end of the defendant's special motion means paying the other side's legal bill, as happened here, on top of losing your underlying claim. So, I mean, really, if you are the party terminating the employment contract based on a morals clause, if you're the hiring party and you're terminating based on the employee's violation of a morals clause, I don't think I can't think of an instance where you would sue, because you do run the risk, especially if it's over public speech about a broad public interest topic, then you do run the risk of being on the losing side of an anti-SLAPP motion.
Right. And in this particular case, it was such a stretch on so many different levels, but you're right. I mean, you're looking at somebody making, comments in the public record based on a public issue. And, it's almost like tracking the language of, the legislative history behind SLAPP.
Right.
And so they just really, kind of stepped in it.
Yeah, I think
by their own volition.
I think they did. I mean, a thought for performers on this side, right? So public commentary about a controversial issue, it carries real legal protection when it's tied to genuine advocacy on a matter of public interest. And that's a real meaningful shield. But it's not unlimited, right? A morals clause, if there was one that was narrowly drafted around genuine scandal, personal misconduct, or criminal conduct, that's still going to be enforceable. And that will be able to survive an anti-SLAPP motion. So the line this case really draws is between policing behavior and policing viewpoint. And views and the venues that blur that line, or the hiring parties that blur that line, they're taking on a real litigation risk here.
Yeah, and I think, part of the miscalculation too was to equate criticism of the institution with a moral transgression.
Right.
And sometimes you become too deep in your own advocacy.
Yeah.
And yeah, so on many levels, I think that they just really it was ill-advised.
Right. And it cost them over $250,000.
Cost us, right?
Right. So let's wrap this up. I'm concerned that this might have been a little dry for our listeners. So for the listeners that made it to the very end, I've got a little treat here. I have a limerick. There once was a center that sued Red for canceling a concert instead, but his speech was protected, the contract rejected, and the center paid fees in the end.
Bravo.
Bravo.
Beautiful.
All right, Richard, thank you. Always great to have your insights. And thank you to our listeners for hanging in there, joining us on the briefing. If you found this episode helpful or interesting, or if you liked my limerick and want me to do more, please take a moment to subscribe, like, share it with your network. And we'd love to hear from you. Leave a comment or review, including a review on my limerick, and let us know what topics you would like us to cover in future episodes. I'm Scott Hervey. I'll see you next time on the briefing.